Good afternoon, everyone, and thank you for joining us here today. My name is Crady DeGolian. I am the Director of CSG's National Center for Interstate Compacts, and we are tremendously pleased and excited to be convening the first in what is a planned ongoing series of webinars to discuss the evolving use of interstate compacts. Given the political climate today, compacts have become an increasingly popular tool for state policymakers to rely on to facilitate interstate cooperation and foster sustainable policy change. While the use of interstate compacts dates back to the founding of the country, they are increasingly being used in new and creative ways. And to that end, we thought the timing of today's webinar and the beginning of this series of webinars was perfect. I am joined here at our headquarters by Rick Masters, who not only serves as our special counsel to the National Center for Interstate Compacts, but is one of the national leading scholars on the subject of interstate compacts. I will briefly run through some of the highlights of Rick's bio, and then we'll talk a little bit about some of the housekeeping items associated with GoToWebinar and that sort of thing. And at that point, I'll turn the floor over to Rick for his presentation. Mr. Masters is the Special Counsel for Interstate Compacts and legal consultant to the National Center for Interstate Compacts, operated by the Council of State Governments. He also provides legal advice and counsel to 3 compact commissions which are affiliated with CSG, and has written and spoken extensively on the subject of interstate compacts. He was the principal draftsman of the Interstate Compact for Adult Offender Supervision, enacted by all 50 states, the Interstate Compact for Juveniles, enacted now by 48 states, and the Interstate Compact on Educational Opportunities for Military Children, enacted by 39 states. Additionally, Rick helped to draft, or I should say redraft, the Interstate Compact for the Placement of Children, which is currently under consideration by a number of state legislatures. Rick has testified before numerous state legislative committees on these subjects, and in conjunction with CSG has also consulted with the National Highway Traffic Safety Administration, the U.S. Department of Justice, National Institute of Corrections, and the Office of Juvenile Justice and Delinquency Prevention, and the U.S. Department of Defense concerning various interstate compact projects, including some of those I previously mentioned. Rick is also the co-author of the book on the law and use of interstate compacts entitled The Evolving Use and Changing Role of Interstate Compacts, A Practitioner's Guide. That book was published by the American Bar Association in 2007 and is still, I believe, available on Amazon for anyone interested. Let me just say it is a tremendous honor for us to have Rick here today, and we are excited to let him run through these slides. In just a minute, I'll actually turn the floor over to Rick for his presentation, but I did just want to take a minute to make some sort of housekeeping items. Following the slides, we will have time for Q&A. There are 2 ways I would suggest submitting questions for Rick to answer. The first would be to use the question box on the bottom of your GoToWebinar dialog box. Those questions will come into our office and we will ask them of Rick. The other option would be to send an email directly to my colleague Nathan Dickerson with the National Center at ndickerson@csg.org. That is ndickerson@csg.org. Either of those methods will allow us to get questions to Rick should they be available. I anticipate Rick's talk will probably last about 30 minutes, so there should be plenty of time for Q&A before we adjourn at approximately 3 o'clock. Additionally, I should note that this webinar is being recorded and will be posted on CSG's website in the next few days should you wish to view Rick's slides or re-listen to portions of the presentation. With that, I will go ahead and turn the floor over to Rick, and we will go ahead and get started.
Crady, thank you for the opportunity to be here today, and I appreciate all of you who've taken the time out of your busy schedules to learn something more about interstate compacts. As Crady has mentioned, the purpose of this webinar is to give you an overview of this important public policy mechanism that is increasingly being used by states to manage interstate problems that states wish to continue to control the regulation of, but cannot do that unilaterally. There are a number of issues that are related to this subject that will be beyond the scope of this presentation. We hope to make this, as the name suggests, a basic primer in interstate compacts so that you'll leave this webinar with a greater understanding of how these mechanisms operate in practice and the authority under our Constitution and laws for the use of this mechanism. And then we'll give a few pointers on adoption of compacts and the typical methods that have been used in conjunction with the Council of State Governments as well as other organizations in the adoption of these mechanisms. And as Crady mentioned, we want to give you plenty of time for questions. The simplest explanation that I can give you of an interstate compact and what it is would be that it is an agreement between states which has been embedded or enacted into the state code by each member state legislature. And arising from that interstate agreement that is statutorily authorized are certain duties and obligations that are common with any contractual agreement, except in this case, the parties are not commercial entities or individuals, they are states. Interstate compacts have been used throughout our history to manage a variety of problems. You will find within our federal Constitution, from the time it was ratified in 1789, in Article 1, Section 10, Clause 3, reference to interstate compacts as a tool that the Founding Fathers were so prescient to know even at that early date would be useful for the states in the collective management of problems that the federal government could not or should not perhaps handle. For that reason, we refer to them, as the slide here suggests, as a simple, versatile, and proven tool that addresses common problems in an effective manner and creates a variety of benefits, including some economies of scale, allowing the states to provide for uniformity that typically many assume can only be achieved through preemption by the central federal government. This is an alternative to that method of regulation of interstate problems. It allows the states to retain collective sovereignty over issues belonging to the states. While compacts have existed since the beginning of our constitutional republic and are rooted, in fact, in our colonial past, even predating the Constitution, where the early colonies used compacts to resolve boundary disputes, what has changed with interstate compacts is the methods and the sophistication of these mechanisms and the increasing use of them for managing ongoing administrative problems that require regulation. As stated in my opening, these are contracts, and so contracts are determined even when they are between states based on traditional common law principles, and courts which consider the construction of interstate compacts, the application of interstate compacts, and legal disputes arising about them in the context of contract law. To briefly demonstrate the contract law analogy and how compacts achieve contractual status, the first state to offer legislation and to enact legislation adopting a compact is in essence conveying an offer to any other state which wishes to enter into the contractual agreement to accept that agreement. For that reason, under traditional contract principles, the terms of the offer, i.e. the statute which is adopted by state number one, has to be substantially similar in every state which accepts that offer in order to achieve what contract lawyers would call a meeting of the minds or a mutuality of obligation. Both parties have to be agreeing to the same general principles. Once a compact has been enacted by two or more states, it achieves the status of a contract. And in fact, as I have mentioned, you will find authorization for states to enter into these mechanisms in Article 1, Section 10 of the Constitution. Although a state can't be bound to a compact to which it has not consented and has not adopted, once a compact is enacted, the provisions of the compact take precedence over conflicting statutes of the signatory states, and I'll give you some reasons for that in just a few seconds or so. Once adopted, a state can't unilaterally nullify, revoke, or amend a compact unless the compact so provides and without the consent of the other parties. Like any other agreement, once you've entered into a contractual mechanism, all parties must agree if that mechanism or that contract is to be amended. There is a recent court decision that any of you interested in this subject, and particularly from the point of view of the legal authority and the extent of the obligation of interstate compacts, should review this case. And this was decided by the United States Supreme Court in the case of Alabama versus North Carolina in 2010. There are a number of important and salient points that are part of this decision, but three which I think are crucial are featured on this slide. The court, as it has in previous cases, reaffirmed the idea that neither the Supreme Court or any other court for that matter can properly read absent terms into an interstate compact due to the federalism and separation of powers concerns which would arise if the court was to, in effect, rewrite the agreement, and I'm quoting here directly from the opinion, that is an agreement among sovereign states to which the political branches have consented. Similarly, because it is a contract, the Supreme Court, not surprisingly, reaffirmed the notion and the holding that a court, considering the enforceability of a compact provision, cannot order relief inconsistent with the express terms of the compact, and again, quoting from the opinion, no matter what the equities of the circumstances might otherwise invite. Thirdly, the Alabama versus North Carolina case stands for the proposition that the 11th Amendment will not bar enforcement of the provisions of an interstate compact against a member state acting in violation of the terms of the agreement. Obviously, if the compact is to have any ultimate effect, the 11th Amendment could not bar what the state has already agreed will be its obligation by enacting the compact in the first place. And this case reaffirms that principle. The purposes of interstate compacts are divided typically into three areas. We still use them to define boundaries between states. We also use compacts to institutionalize and manage such things as the allocation of natural resources. I frequently have been quoted as saying, show me a river basin and I'll show you an interstate compact. That's because rivers and other natural resources generally extend along more than the territory of one particular state and are by nature problems that can only be managed, or resources that can only be managed on an interstate basis. Thirdly, and as stated previously, with increasing frequency, compacts are used to create administrative agencies which have a jurisdiction over a wide variety of state concerns. We have cited some of them here, and it's safe to say that this is a diverse universe, and compacts are used to manage everything from horse racing and wagering to things such as public safety, corrections, education issues, multi-state taxation, and a variety of other interstate problems. Again, if it's a problem that transcends the authority of your state to deal with unilaterally and requires more than one state to manage it, the problem is a candidate for an interstate compact as a potential solution. And we have a number of them currently in effect. Approximately 200 compacts have been adopted since 1789. About 38 of those are dormant. On average, each of your states, and we have a variety of states represented here today, is a member of approximately 24 compacts, some more, some less, but again, these are not new instruments, and these are not instruments with which state legislatures are unfamiliar, having used them on average 24 times per state. In fact, the first compact to engage in what I would call administrative regulation in the modern sense that we think of administrative regulation was as long ago as 1922, when the Port Authority of New York and New Jersey was entered into to regulate all forms of transportation between those two states, whether it be subways, trains, buses, ferry boats, or any other conveyance. They have a $1 billion budget and its own police force, a very wide variety of regulatory responsibilities by that compact and others since. We have a map here which hopefully will be showing up on your computer screens clearly enough for you to read it, showing the number of states according to our records at the Council of State Governments that states have entered into and the membership of each state in compacts. More information about the specifics of each compact is available through the National Center for Interstate Compacts website, which you will find at the CSG website when you click on the appropriate menus, and we can give you more help with that if you need it. For you political scientists in the crowd, we have a chart here on this slide showing the development and use of compacts over a period through, I believe, 2005. Now, we have updated this chart, and for some reason this slide doesn't reflect it, but you'll see here pictorially illustrated on this graph the ebb and flow of the use of compacts, and can see certainly that in recent years compacts are clearly on the upswing. There are a number of compacts that I could call your attention to, but after reviewing the list of participants today, we picked out several that we thought would be those with which some of you or many of you would be familiar. And this is by no means an exhaustive list, but it illustrates the diversity in the Interstate Compact universe. The Insurance Product Regulation Compact, for example, allows central filing for certain types of life insurance products that are offered among the states to avoid a multiplicity of conflicting regulations concerning filings for such products. The Interstate Compact for Adult Offender Supervision, that is the only law in our country, state or federal, that comprehensively manages the transfer of offenders from one state to another. And permission must be secured under the auspices of the Interstate Compact for Adult Offender Supervision for any person on parole or probation to relocate to another state. Similarly, in the juvenile universe, the Interstate Compact for Juveniles serves a similar function for juvenile offenders and runaways to both put them across state lines in places where they belong for their benefit as well as for public safety, and for the return of runaways who have gone to places that they shouldn't be and to get them back to where they belong. Very recently, CSG has been pleased to work on the Interstate Compact on educational opportunity for military children, which provides a level playing field, or at least a more level playing field, for the children of our members of the military who have been deployed on active duty and who are required to move their families on average 6 to 9 times during their careers, and disrupting the education process frequently when they have to make these moves. And this compact was designed to make that landing softer when they have to go from one state to another, and to allow them not to be penalized, at least, because their parents have chosen to serve our country. There's also the Midwest Interstate Passenger Rail Compact, the Driver License Compact, Emergency Management Assistance Compact, and the Great Lakes St. Lawrence River Water Resources Compact, among many in that area of natural resource management. So in summary, I think it would be appropriate to observe and correct to observe that the advantages, or among the advantages of interstate compacts, are that they are a flexible means of cooperation in the sense that all states can collectively manage the problem, and they are enforceable, so that uniformity can not only be established but can be enforced among the member states. That uniformity can be achieved without federal involvement, preemption, or in some cases without federal consent. While states give up the right to act unilaterally when they enter into a compact. Frankly, as previously suggested in the opening of this webinar, you really can't manage a problem once it passes across your state borders anyway, without some sort of interstate agreement with which to do that. And what compacts allow is what we call states' collective sovereignty, so that together states can manage a problem in a uniform basis. This also provides opportunities for states to work cooperatively, in many cases with federal government partners who, perhaps not surprisingly, often feel that states should continue to have responsibility for managing these areas, and in some cases have been very supportive of efforts to adopt or amend interstate compacts with important national priorities at stake. Potential disadvantages ought to be noted, although we believe that these can be surmounted in every case. This can be a lengthy and challenging process. It takes time, particularly if the compact is one in which all 50 states have an interest, to get all 50 states back on board. But if there are appropriate organizational advantages that have been put into the process, as we'll demonstrate here in a few minutes in the last part of the slide presentation, you can cut down on the length of that process. And in some cases, for instance, the Interstate Compact for Adult Offender Supervision was online with a new compact in 30 months from the date the first state enacted until it triggered the administrative process set up under that compact. More recently, with the Interstate Compact for educational opportunities for military children, that compact went online in less than a year. While there have been some that have raised the issue of potential loss of of individual state sovereignty, as previously stated with regard to the last slide, you're giving up something that you really don't have with regard to the unilateral ability to influence what goes on after the transaction goes across your state borders. So I think instead of interfering with state sovereignty, if looked at and utilized properly, compacts actually reinforce state sovereignty and are what I sometimes refer to as the poster child for federalism. This is a way that the states can exercise their collective sovereignty in a way that does not make it necessary for the central federal government to become involved, even if they have the enumerated authority under the federal Constitution to do so. There does involve, at times, some delegation of state regulatory authority to interstate agencies. And while this is viewed by some as a disadvantage, it is no more so than delegation of other types of administrative or regulatory authority within your state, which is done on a routine basis where there is a sophisticated area of regulation which needs expertise of a particular kind, and which can be appropriately limited by the state statutes of each member state so that that delegation does not go beyond the scope of what the legislature intended. The authority of states to delegate authority to what is commonly referred to as an interstate administrative agency has been reinforced and approved of by the United States Supreme Court as long ago as 1951 in the case listed on the slide, West Virginia ex rel. Dyer versus Sims. And as former Justice Felix Frankfurter observed in that case, a state legislature's ability to delegate regulatory authority to an administrative agency is one of the axioms of modern government. And that case certainly extends that administrative law doctrine to the creation of interstate commissions by compact. There is also some important language bringing the past into the present in that Alabama versus North Carolina case decided just last year, which also reinforces this idea that a compact commission made up of the member states to administer an interstate compact clearly has authority to enforce that administrative agreement as well as the compact provisions. There are other forms of multi-state cooperation. Compacts are not the only way in which states can cooperate but we believe that in the appropriate case where regulation is involved, many times the compact is the best alternative. Certainly, multi-state legal actions, such as were encountered under the tobacco settlement that's referenced here on the slide, which the National Association of Attorneys General was very actively involved in, is certainly one way to manage a problem, but typically it's a very discrete legal issue, and litigation, as I think even many lawyers would agree, is not necessarily the best way to resolve a dispute, but sometimes may be the only way. Uniform state laws are certainly an alternative that states have used in the past. In fact, the National Conference of Commissioners on Uniform State Laws, now referred to as the Uniform Law Commission, have frequently advocated uniform laws that have been directed at the resolution of a number of interstate issues. One of the problems with uniform state laws, however, is that frequently they are not in fact uniform, and that states generally are free to add certain provisions, which they do at certain times, which may defeat the purpose of the uniformity, despite the best efforts of those promoting such laws to keep everyone on the same page. In contrast, an interstate compact requires uniformity among the member states in terms of the agreement that is enacted in the terms of the compact, and those terms may be enforced, so that that uniformity is not only existing in theory, but also in practice. Finally, there are what I think we could refer to as administrative agreements or memoranda of understanding. Typically, these are used on a much narrower basis between particular agencies of government, and usually for a specific purpose that typically does not involve ongoing regulation. If the problem that seeks to be solved is one in which there are repeated and serial challenges that need to be managed on a regulatory basis, an MOU is simply not sufficient to manage that problem. So, in retrospect here, to summarize, some of the key benefits of interstate compacts are effectiveness and efficiency, achieving uniformity, as well as economies of scale with generally lower cost than trying to manage a problem on a state-by-state basis in a conflicting manner. There is flexibility and autonomy given to the states to manage these problems so that states can determine their own destinies on a collective basis rather than having national standards prescribed by Congress. Compacts frequently allow for and promote dispute resolution among the states. While enforcement can be achieved through legal action, many compacts in the modern era include such provisions as alternative dispute resolution for various types of problems and disputes that arise under both mediation as well as arbitration. Compacts provide for state and federal partnership. It is possible for the states to continue to manage the problem while the Fed is a partner and still exercises an appropriate role. In fact, there are compacts in which a federal delegate has been named to the compact commission or interstate board used to manage the problem, and there is precedent for that. Finally, compacts, in our view and in our experience here at CSG, allow cooperative behaviors to be achieved or to be implemented so that win-win situations are accomplished with respect to the problems sought to be managed. Let's switch to more of a focused emphasis on how compacts are typically organized and orchestrated in terms of the drafting and the promotion and achievement of compacts, should there be an interest in applying these principles on a practical level. Among the benefits that have been demonstrably achieved by many of the existing compacts include such things as national data and information sharing problems. For instance, the Interstate Compact on Adult Offender Supervision has an electronic data system that now includes all 50 states and the territories, so that information about offenders who wish to transfer between states, some of whom are public safety risks, can be sent electronically and virtually instantaneously, rather than relying on the inefficiencies of U.S. mail or other forms of much slower delivery. Compacts provide some operational benefit in terms of enhanced enforcement and compliance mechanisms. As said previously, unlike an MOU or a uniform law, compacts generally have built into the mechanism provisions for both enforcement and compliance with the compact principles and the rules. There is uniform compact language and rules that can be implemented in order to achieve the desired uniformity among the states. Many compacts take advantage of the opportunity for administration through a national office or staff if necessary. The states can achieve the level of governance that they believe is necessary and actually establish an appropriate governing structure to manage regulation among the states of a particular problem. This would include provisions for such things as national training, uniform operations and procedures and rules that are communicated to all of the stakeholders, the member states and the stakeholders. The compacts can provide a national interface with external stakeholders and national organizations who can participate at times even in an ex officio role on the management or governing structures of these compacts where appropriate. And compacts can provide for interface with other existing interstate compacts that have similar goals and responsibilities and relevant responsibilities. In order for a compact to succeed and move from theory into process and practice through adoption by member states, we've got 5 keys to success featured here on this slide. Like any other type of organizational goal, there has to be an inclusive process in which all of the relevant stakeholders, both governmental and private, are involved. There has to be an effective way to educate potential stakeholders as to the nature of the problem and the proposed means of solution through an interstate compact. Once a compact idea has moved from theory into concrete reality in the form of a compact statute, there has to be a broad-based strategy for getting that information to each potential member state so that there's understanding and an opportunity to raise questions and problems as part of that process. It's also important that each state have a champion who is interested and has a vested interest in seeing this particular problem resolved within their state and is willing to provide access to information and resources for legislators and other policymakers within each state about the need for the compact and why things are being proposed in the compact solution, and to give opportunity for feedback. Also, a proactive transition plan may be necessary where, for example, in several compact projects that have already been mentioned, one compact is revising or replacing an old compact so that we move from the old regime into the new order with regard to regulation of the new compact. Typical key players are listed here. I won't read them all off, but you can see them. Obviously, the usual suspects that you would think would want to be involved and need to be involved in any such process in both the executive and legislative branch, and certainly in compacts involving the courts, the judicial branch as well. External stakeholders are as wide a variety as the nature of the area sought to be regulated or the problem to be solved, and this could include a variety of national associations, academic institutions, private industry, and federal agencies. Typically, the development process, while not exactly a cookie cutter, which is common to all compacts, there are some typical ways that compacts have been developed and that CSG has been successful over the years in promoting these activities. Usually, the process begins with the assembling of an advisory board composed of the appropriate stakeholders that takes a look at the problem and attempts to dig deeper into both the problem and the solutions that could be offered through the language of an interstate compact. That is typically followed by the appointment of a drafting team involving a smaller group, but still an important group of stakeholders, issue experts, legislative drafters, and others, which seek to implement the advisory board recommendations and to come up with the actual compact language. After a final draft, or at least a comprehensive draft, has been prepared, typically that would be circulated to appropriate stakeholders in addition to the advisory group, and a final product ultimately is concluded, which would then be released to the states for consideration in the respective state legislatures. Things to be included, this is just a general summary here, and I'll leave this to you to look at later, perhaps. Obviously, the purpose statement, the definitions of the compact, what to be included, what not to be included, and provisions for such things as regulation where necessary, amendments, bylaws, rulemaking, and dispute resolution. Here is a list of typical compact provisions, and when you look through these, you can see the particular substantive provisions that are grouped around each of these general categories, which are typical to compact agreements. The enactment process is a combination of education and support from the existing network of stakeholders. Certainly, policymakers, particularly legislators, need to have a comfort level by understanding both the problem and the reasons for the proposed solution, and in many cases will become advocates for this process once the problem is understood, because frequently this does permit the state to continue to manage the problem and avoid the need for some federal intervention outside the process. We have a slide here on transition and operation in terms of how the compact is structured and the various considerations for implementing the compact. Bottom line, and in summary, I would say the values that we seek to promote and that compacts can help achieve are cooperative behaviors instead of self-interest, collective action instead of individual action, uniformity rather than disparity, alliances between states, and cooperation, and the opportunity to work together without the need for federal intervention, but with a partnership, if necessary, with Washington or federal agencies. We have our contact information here on the slide. I know there are some that have questions, and I'm going to return this to both Crady or Nathan, and we'll try to answer any questions that come forward before we leave.
Sure. Thank you again, Rick, for taking the time to be here with us today, not only for sharing your expertise, but for reaching such a wide audience about the mechanism and the growing use of interstate compacts. We already have a couple questions that have come in, and I will get to those in just a minute, but it is not too late. By my watch, we've got about 15 minutes or so for Q&A. There are, as I said at the beginning, two means for you to go ahead and ask a question. The first is to utilize the questions dialog box on your go-to webinar box. Those questions will come into our staff here and will then be funneled directly to Rick for his expertise on. The other means that you are welcome to use is to submit an email, your question via email to Nathan Dickerson at ndickerson@csg.org. A couple housekeeping questions that came up. First, somebody asked if the PowerPoint will be available, and the answer to that question is yes. Not only will Rick's PowerPoint be available, but we will also be able to provide his oral comments online. Those will probably be posted on our website here in the next couple days, and I will send an email and link to everyone on the call once they do go up. The other question was, will this be available on YouTube? I think that is something that we could work out. It hasn't been a question that's been raised before, but it's a very good one and one that we'll take a shot at figuring out. The first question that came in pertains to congressional consent, and Rick reads as follows. From what I understand about compacts, they require congressional consent. Can you talk a little bit more about how that process works and when it is necessary? So I'll turn it over to Rick.
One of the most common misconceptions about interstate compacts, and I blame the language of the Constitution, although I idolize the document as well as most of you, I trust. The compact clause of the Constitution is phrased in such a way that a simple reading of it seems to suggest that all compacts require consent. I believe the literal language is, with a few ellipses inserted here, is no state may enter into any contract or agreement with any other state without the consent of Congress. The Supreme Court of the United States has, for the last century, construed these words to mean that not all compacts require consent. So apparently the word any compact or agreement as used in the compact clause of the Constitution does not mean all. It only means some. And one of the cases that is of more recent vintage dealing with this subject involves the U.S. Steel versus the Multi-State Tax Commission, which is a Supreme Court case from the 1980s, I believe. And what the Supreme Court has held is that the only compacts that require consent of Congress in order to go into effect are those in which some enumerated power of the federal government has been interfered with or threatened by the action of the states. So in other words, if Congress doesn't already have the enumerated authority to govern the problem as set forth in our federal Constitution, states need not obtain consent in order for the compact to be adopted or to go into force.
Rick, as a follow-up question, we have a question pertaining to congressional consent from Daryl Dorsey, and it is as follows. Texas, Oklahoma, and Georgia have adopted state statutes creating an interstate advisory health care compact. The language seeks in part to redirect all federal Medicare funding back to the member states. Does this compact require congressional approval, and if so, what would the vote requirement be?
Again, if the federal Constitution enumerates the authority, and for Congress, that would be Article 1, Section 8 of the Constitution, if it provides that Congress has the authority to regulate or manage or create laws concerning that particular area, then congressional consent would be required. Whether or not this particular compact requires consent, again, would be answered, I think, by that doctrine. And since it seeks to obtain a result that involves a redistribution of funds that come through the federal government, I would think that consent would be required. I'm not prepared today, without having seen all of the language, to give you the legal certainty of legal advice, and I hope nothing is intended in this broadcast to constitute a specific legal advice on a particular issue, but certainly it appears to me that if it does interfere with or in some way relate to Congress's power, consent might be required.
Thank you, Rick, and thank you, Daryl, for that question. The next question I received is as follows. From what I understand about interstate compacts, there is frequently a minimum number of states required before a compact can take effect, and, for example, its commission can begin business. What is that minimum number of states, if there is standard language, and how frequently does it take, or how long does it take to reach that minimum number of states?
It really depends about the nature and scope of the problem. And when the compact is drafted, that's an important issue that always is raised and should be raised during the process by which the compact is being drafted, so that there is some political legitimacy to the agreement. So using that as a general guide, I think the answer in part then depends on how many states is it anticipated will ultimately be participating in the compact, or what is the goal for participation in the compact. If it's a 50-state compact, perhaps you need a larger number to give what I think, again, I would refer to as political legitimacy to the mechanism before it actually is activated. If it's a regional compact that involves, for instance, a natural resource issue with a smaller subset of states, perhaps a smaller number would be required. Now, this could also be influenced by things such as the number of transactions that are occurring that are sought to be regulated by the compact. For instance, if it's a particular type of business transaction, perhaps the particular type of transaction occurs with greater regularity in just a few states. So if market share, for example, is an issue with regard to the regulation, perhaps that would be the way to obtain the political legitimacy necessary. And once you have a sufficient number of states constituting or comprising that portion of the market, or those number of transactions, perhaps that's another way to look at it. But no, there is no set number that is required, but I think it is a discretionary decision that ought to be based on some concern about the legitimacy of the process.
Thank you, Rick. I've got one last question from the audience, and it is as follows. Interstate compacts are frequently viewed by state policymakers as a way to avoid federal preemption. Can you talk in a little bit more detail about how that process might work, and give some recent examples of compacts that were used to stave off federal preemption?
The threat of federal intervention is one of the greatest motivators to states to adopt compacts, in my experience. And while I will not state that this was the sole reason for several of these compacts that I'm going to mention to you, it certainly was an issue at the time either comprehensive amendments to these compacts or the adoption of these compacts was completed. One of those was the Interstate Compact for Adult Offender Supervision. There was the threat of some congressional action to manage that particular problem, arguably because offenders cross state lines. That certainly involves enumerated federal power, and Congress would have had the authority to regulate in that area. Instead, the states banded together to comprehensively deal with that problem. The Interstate Compact for Adult Offender Supervision was the result, and is working, I believe, very well to manage that problem, and certainly appears to have averted any potential federal intervention in that area. There are some other issues that are being looked at now with the same thought in mind. One of those came out of Congress recently with respect to the Dodd-Frank Wall Street Reform Act, and CSG has been working with several other organizations, including the National Conference of Insurance Legislators and the National Conference of State Legislators, to adopt a compact that is already online in 9 states that regulates a particular type of insurance products that are sold in this country called surplus and excess lines. Again, the Congress enacted a law that suggested that states should manage this problem, but in essence, as I understand the federal law that has given impetus to this compact, if the states are not successful at managing the problem, Congress appears poised to revisit this issue and could intervene. So I think I would cite that as another example where states have attempted to use compacts to appropriately deal with the problem without the need for federal intervention.
Well, Rick, let me once again thank you for taking the time to be here, for sharing your expertise with this audience. Let me also extend on behalf of our staff at CSG a very sincere thanks to everyone who took the time to join us today, not only to listen in, but to also ask several very insightful questions. As I mentioned a few minutes ago, right before we started the Q&A portion, I will make the slides and Rick's presentation available at CSG's website. That process usually takes a day or so, or maybe 2 days to upload. Once it is uploaded, I will share the link via email with this group so that you all can access it easily, share it as you see fit, and review it as need be. I will also add that if you think of additional questions or additional questions pop up following today's presentation, you are more than welcome to contact me either via email or by phone. My number is included there at the contact slides that Rick finished up with. And I should also encourage everyone to visit our website, www.csg.org/NCIC. There you will find a host of compact-related resources, including several of our most recent publications, our ongoing project list, and the Interstate Compacts database that our office maintains, which is the foremost expert on state adoptions and so forth with respect to interstate compacts. Finally, as I mentioned previously, this is the first in what I hope will become an ongoing compact series webinar. We will be in touch with additional details about topics, date, and time here in the next few weeks. And with that, I would once again like to thank Rick for his time and also thank everyone for joining us. And we are adjourned. Thank you all.